I'm a project associate with the Association of Prosecuting Attorneys. APA is a private nonprofit located in Washington, D.C., which serves prosecutors as well as their law enforcement and community partners. Thank you for joining our child abuse webinar today. Today's webinar, Opening Statements, Closing Arguments, is presented by Rachel Mitchell. This presentation is made possible by a grant from the Office of Justice Programs through Office of Juvenile Justice and Delinquency Prevention. We appreciate their financial assistance and commitment to improving the justice system. Points of view or opinions in this presentation are those of the presenter and do not necessarily represent the views of the United States Department of Justice or the Association of Prosecuting Attorneys. At the close of this program, we will email you a brief electronic survey. This survey helps us continue providing quality training at no cost to your jurisdiction and assists in future planning for continuing legal education. If you leave a question in the comment section of the survey, please include your email address so we can get back to you. We are in the process of receiving 1 credit of CLE certification from the state of Virginia for this program. Please do not leave the webinar early, as we will use attendee reports to verify attendance for CLE purposes. During the webinar, you will be able to submit questions for our speakers using the question box on your GoToWebinar bar. The bar is located on the right side of your screen. Questions will be forwarded to our speaker, and we will try to cover the issue during the live presentation. Our webinar will cover a lot of material today, and we may have to follow up with you via email after the webinar. If you need additional assistance, please feel free to contact us directly following the presentation. Today's presenter is Rachel Mitchell of the Maricopa County Attorney's Office in Phoenix, Arizona. As the Sex Crimes West Bureau Chief, Rachel is responsible for prosecuting cases involving child molestation, sexual assault, and computer-related crimes against children. She previously supervised a bureau in a satellite office that prosecuted sex crimes, child physical abuse, domestic violence, and gang and repeat offender cases. Rachel works on sex crimes legislation for her office. She also teaches prosecutors and other professionals nationally in the areas of crimes against children and adult sexual assault. In 2003, Rachel was the Arizona Outstanding Sexual Assault Prosecutor. In 2006, she was the Maricopa County Attorney's Office Prosecutor of the Year. That same year, she also received the Arizona Children's Justice Task Force Award for Excellence for Outstanding Child Abuse Legal Professional. In 2013, she was awarded the David R. White Excellence in Victim Advocacy Award by the Arizona Prosecuting Attorneys Advisory Council. I will now turn it over to our presenter, Rachel Mitchell.
Thank you, Dean. Let me just check. Can you hear me? I assume
yes,
you can.
I hear you.
Okay, thank you. Obviously, you can see the header. We're going to talk about opening statements and closing arguments today. Also, part of that lecture is going to be about building a theory and a theme into your case, because those are critical components, especially when you have cases like we prosecute with family dynamics and acquaintance dynamics. So let me go over the contents of the course initially. I'm going to give you a case example. I'm going to give you some of the facts of the case and then some of the issues that were present in the case. And we're going to talk about how those were woven in to an opening statement. We're going to talk about general principles for opening statements, themes, and then how to build in your theory, and then finally closing arguments. So let me start off with the case example. So the victim, and let me say this, all of the names have been taken out of this. Normally, when I give an opening statement, I do use the victim's first name, for example, but for purposes of this, I'm taking that out. Victim says that when she was 11, her mom's plural husband married her and began sexually abusing her for about the next 9 or 10 years. She's very intelligent. She gave a very detailed description of what happened. and Mom's journals were seized during a search warrant, which implied that she knew something was going on. When her 3 brothers were interviewed, they indicated that they had seen suspicious behavior, including one who had seen actually sex taking place. That seems pretty straightforward, but now let's get to the issues. The victim and the brothers had told police that years earlier that they had falsely accused their biological father, not the defendant, of sexually abusing the victim. All 4 of them did. The victim also had falsely accused a boy from her church group of attempting to rape her when she was 13 years old. The victim was a cutter, had many scars all over her body from cutting. And when she was 17 years old, she was committed to a mental institution 4 different times, twice after suicide attempts. And as you are prepping her for trial, yes, this did go to trial, she tells you, "I'm not crazy, I was faking it when I said I was crazy." So I think we can agree that all of that is going to come in to some degree. So what I'm going to do is I'm going to go over a very small portion of the opening statement, and I want you to listen to some of the things that we integrated into this. This was co-authored with an attorney in my office, Janine Sorrentino. So let me begin. He looked crazy like a wolf, like he wanted to consume me in every single way possible, almost like a rabid dog, because everything he was doing, it wasn't normal controlled motions. It was this frenzy. These were the words spoken by the victim about the defendant. She was talking about a very long night of sexual abuse. To understand how things got to this point, you must understand the history of the family. In 1972, the biological mom married the biological dad, and they had 4 children, the youngest of which was the victim. But the marriage was troubled, and Dad filed for divorce, which became final in 1987. He was given custody of the 4 children, and Mom had visitation rights. 3 weeks after the divorce, Mom met the defendant, and even though he was legally married to another woman, after a short time, he approached the mom about becoming his second wife. On January 1988, the defendant performed a ceremony in which he married himself to Mom, and they each found in the other what they so desperately wanted. Mom got a man, and the defendant got a woman who had a little girl. But the defendant had a problem. Dad had moved the 4 kids to California, and he had to get her back. So during a summer visit with the kids, he told Mom and the 4 kids that God had told him that if the victim returned to California, her father would sexually abuse her. He said the only way to prevent this was to tell the police that it had already happened. To convince the kids to do this, the defendant held a series of meetings that he called prayer circles. And during these circles, he would change his voice, his posture, and his mannerisms, and claim that God himself was speaking through him. He talked excuse me, he talked about the special mission of the family and how they weren't bound by the same rules as others. Being special, even being significant, was a drastic change for the children from the way their father treated them. You'll hear that when they were living in California, they were kept in a separate part of the house, not to mix with Dad's new wife and her children. At the end of the visit, the children returned to California with instructions to report their father to the authorities, and the plan worked. In August of 1993, custody shifted to Mom, but really to the defendant. Victim was 10 years old, and this was the last year of her childhood. Her every movement was controlled by the defendant. She was not allowed to go out with friends, and if she dared even speak to a boy, there was hell to pay. One of the few times she was allowed to go out without the defendant was in May 1996 to a church youth group. A boy flirted with her. He picked her up and locked her in a room by herself. But when she got home that night, she found out that once again, defendant's God had spoken to him, and he told her he knew something had happened, and she had better tell him what. Over the next several days and weeks, defendant did everything he could to force victim to admit her sin. When she told him what had really happened, he called her a liar. He terrorized her by beating her, cutting off her hair, and hanging a doll that looked just like her from a noose. He pointed to that doll and said, "That's going to be you if you don't tell me what happened." Victim had no one to go to. Her mom, the one person in the whole world that she should have been able to turn to, wrote in her journal these words. The boy picked her up and dragged her into a dark room where she consented to the deed, but was protected by the priesthood before she ran out at the end. She is now on her last chance and has less hair. She has to wear a hairband to keep down what sticks up on top. Defendant has a lot more patience with her than I do. I wanted to throw her out with the garbage at that point. So what could the victim do? She gave in, and she told the defendant what he wanted to hear, that the boy had tried to rape her. You'll hear that the defendant didn't want to hear just that he tried to do it. He wanted to hear that he did do it. And he made her reenact his fantasy rape scene over and over again, with himself playing the part of the boy. That was when the victim began to cut herself. In 2000, a classmate caught victim cutting herself in the bathroom, and the victim was hospitalized. And in a strange way, she found the freedom and safety that had been taken from her years earlier. In the hospital, she was safe. She was safe from the defendant's sexual abuse and safe from her mother's jealousy. Over the next several months, victim did everything she could to return to the safety of the hospital. She overdosed on medication, and she pretended to be crazy, deliberately creating disturbances in public places. Now that's, as I said, a very, very short version of this, but let's go back to the slide where we went through the issues, and you can see we addressed those in a narrative form through the opening statement. So what are the principles that we used in this opening statement? Let me scroll ahead here. First of all, we made it visual. In these types of cases where there's a familial relationship usually between the offenders and the witnesses and the victims, it's very helpful to give the family, or give the jury, a family tree. In a trial I did 2 months ago, we actually gave them a piece of paper so that they could follow along and understand who's a stepchild, who's a full biological child. The opening was given in a very narrative form. We did not do checklists. We did not go through elements. In fact, while we did go through the charges in the real opening, that was just a very small portion of what we did. And the bad facts, the issues that I told you up front, were presented as simply part of what happened. And the dynamics that were impacting the victim were explained. So let's talk about some general principles. Obviously, you've heard on opening statements that this is the purpose. Get their attention, give them a roadmap, and get them stirred up. That's kind of a basic approach to opening statement. When you are in this type of case where there are so many dynamics and so many issues, you also need to tell them your theory of the case and get them thinking or processing information like you. What that means is this: you're explaining to them the dynamics of what's going in the family, and so even if you can't throw every single little issue that might come in at trial into your opening statement, when the jury hears it, they will be able to integrate it into what they know about the dynamics and say, that makes sense. Of course that's what happened. And so they are processing information like you because they understand the dynamics. And this, again, we go back to some basic opening tips. You tell a story. You create word pictures using descriptive language. I could not personalize the victim as much in this training, but of course in the real opening statement we did. You can use admissible demonstrative evidence. I think people get skittish about that because it's not in evidence yet, but so long as you have a good faith basis to believe that it will be, you can use demonstrative evidence. You can also use other visual aids. Here's one that I use very frequently. We have different statutes in Arizona, and I'm sure many of your jurisdictions have different statutes with different elements. And so sometimes we'll charge molestation of a child, sexual conduct with a minor, sexual abuse. So I will go over the elements and actually tell the jury, you may want to write this down, because they need to know what they're listening for, the type of touch, whether it's an external touch or whether it's penetration, for example. And they need to know what they don't need to listen for example, lack of consent. Another way I do it is when you have multiple counts related to a victim. So in the case that I read to you, part of the opening, we had 9 different counts. We needed to break them down, this is a different case that you're seeing here, into different counts so that they know what they're listening for. And I usually will stop if I don't see them writing, and I'll say, you're going to want to take this back, and I'll wait until they write this down, because otherwise at the end of the trial what you're going to get is, okay, which count is which? And sometimes the instructions are not as helpful to them as we would hope. You also have to decide where to begin your opening. Are you going to tell it in a chronological fashion? Are you going to talk about the crime itself and work backwards, the discovery of the crime? Or start at the end and explain how it got to that? As you can see in this opening, I started with a quote that took place several years after the abuse started, but several years before it was discovered. So I started in the middle. And then I went back and introduced the family and introduced the dynamics of how that happened. And that was just a strategy call on our part, where we wanted to capture their attention with this quote that the victim spoke, and then go through chronologically so they could see how the dynamics developed. If you have, for example, a neutral witness, you can also start with them, because that is your unbiased person. And what their perspective is going to be as close to what you expect from the jury to have. And it's very important to build your theme into your opening statement. So that might be something that you start with. In this case, I did not start with the theme. The theme that we had throughout the case was Stanley Reimer's God. But you certainly could start with a theme, and we're going to talk about various themes that I've used over the years of prosecution. The quote, if it's a quote from the case, make sure the quote's admissible. And then make sure you admit it. Have the victim testify to it, for example. So let's talk about some themes that can come up in child abuse cases. A theme is not just a catchy little slogan. It's a word, phrase, or idea that works to remind the jury of your theory of the case, your big story, overview of the case. And one of the mistakes that I see attorneys make is they pick a theme that addresses the strength of the case. That's really not necessary. For example, when I'm teaching here, I tell them, you never have to have a theme that is 5 bullet wounds in the back of the head. That's a strength of your case. You have to anticipate what the weakness of the case is and guide your theme toward that. So for example, in the case I read to you, the weakness is, it sounds crazy. I mean, the victim is lying about other people, and she's, there's other stuff that I didn't talk to you about running away and other false allegations she made. So the theme that was chosen was Stanley Reimer's God, to continually remind them that there was a manipulation going on that involved religious overtones. So general themes. Let's talk about secrecy. That's a general theme. So a secrecy general theme is good for when the victim doesn't report right away, for example, or has underreported the acts. For example, we know that victims often piecemeal disclose, and later on much more information comes out as they become comfortable with the system and trusting of the system. It's also good for when family members knew. If the mom was aware of that, or siblings were aware of it and they also kept the secret. It may be something where if the victim recants, you want to talk about secrecy as a general theme. Your specific theme, though, is sort of that catchphrase that is sort of the drumbeat throughout your opening statement and really your trial and your closing. So a specific theme example of secrecy is the family had, a family secret, or something was wrong with Mary. I had that theme when I had a victim who came forward after a sexual harassment training at school. And what the teacher told me was that she had gone around the class saying, how would you feel if this happened to you? And all the kids, being preteens, would say pretty much the same thing as the other kids. I would be mad, I would be sad, that kind of thing. But when it came to Mary, she said, I would be embarrassed. And it stood out. And that teacher made it a point to just kind of hang out after that class. And that's when Mary came forward and said that her sister's husband had raped her. Now, I didn't have a lot of corroboration. It was a late disclosure, so there's not going to be DNA. There were no medical findings, of course. And so what I had to build up was that corroboration, and so that I used the teacher to corroborate her that she noticed that there was an issue before she disclosed. Something was wrong with Mary. So it goes to the weakness of the case. Here's another example. This was a trial that I did in December. This was a case, well, actually this is self-explanatory what happened. So an author once wrote, dysfunctional families. It's hard to see what's going on when you're inside of one. That dysfunction was so distracting that it led to a mother's blindness, a family's secret, and a young girl's silence. Then, as you can see down below, I introduced them to the family. This is the case where I actually handed a family tree to the jury. And then it explains how this blindness, secret, and silence work together. So the mom knew that the marriage was in trouble. She thought he was having serial affairs, and actually he was, in addition to molesting her daughter. And so her way of dealing with that was just not to be there. So when she came home, she was tired and not very talkative. So the kids felt like, we can't go to her with what we're seeing go on between dad and sister. And that, as you can see, they paved the way for the defendant to go straight at the victim. So that's one of the ways to talk about dysfunctional families, is getting to the weakness of the case, which is a lot of people knew this was going on. Mom was blind, and she really was blind to it, not willfully blind. And how did this go on for 5 or 6 years? Another example, I had a case where a 7-year-old girl was found dead in mom's boyfriend's bed. And because of a series of things with the medical examiner, I was unable to charge homicide. But we did charge him with sexual conduct with a minor, sexually abusing her. And so I had to craft an opening statement that did not blame him for the homicide, but still explained why this sexual abuse had been going on and had not been disclosed. So this is what we chose to do. People who do evil fear the light because it will expose their deeds. The defendant in this case had such a dark secret. He was sexually abusing his girlfriend's 7-year-old daughter. And then if you look at the last paragraph, that was our way of very overtly not blaming him for the homicide, so that we could not be overturned on appeal for even intimating that he was responsible for it. The death of a child is always a tragedy, but for the defendant it was a catastrophe because it brought out the secret. So again, secrecy kind of goes to the weakness of the case, that this was going on and nobody told. Another general theme you can have is fear. And again, same scenario as the one under secrecy. When the victim delays reporting or underreports, or the family knows, or the victim recants, of course. And a specific theme example would be the high cost of telling the truth. And that way it helps you explain to the jury all the things that happened to the victim after she told, and yet she's still here talking to you and telling you what happened. Or if she's recanting, no wonder she's recanting. So the high cost of telling the truth can explain the fact that dad went to jail or dad left the home because he wasn't allowed to have contact. And so now mom's working a couple extra jobs and mom is not happy with the victim. Maybe mom's saying things to the victim like, because of you, I can't buy shoes for your brother. Maybe the victim and her family have had to move to worse housing area. Maybe they had to sell their house and move to an apartment. The high cost of telling the truth. So again, it explains why she's recanting, and if she's still holding on to the story, she's doing so even though it's cost her dearly. It goes to her credibility. Vulnerability. This is one when your victim has issues. So when the victim is troubled, maybe the victim has a drug addiction, teenagers, or was drinking, or has a reputation, for example, at school as a troublemaker or a liar or the kid that no teacher wants in his or her class. Victim has credibility issues because he's constantly in trouble. Or if for some reason the victim was previously molested and this is coming in for whatever reason. So these are some specific themes that you might want to look at. He picked a child that no one would believe. That shifts that weakness of your unbelievable child onto the offender and explains that that's why he picked that child, because he's a predator and he's going for the vulnerable. Predators prey on the weak, not the strong. Another example. This is a sexual assault case, but I think it really illustrates the vulnerability well. So this was a guy that was pretending to be a cop, and he made a prostitution deal with the victim in this case. And once that happened, he pulled out a fake badge and fake handcuffs and told her that she was going to have to either go to jail or work it off. And she had already been busted one time for prostitution, so her second such arrest would involve 180 days in jail. And what the victim told me was she was staying in an extended stay hotel room with all of her belongings. She was young. She had been kicked out of her house by her dad, who was abusive, alcoholic. And she said, if I had to go to jail for 180 days, the extended stay hotel would throw all my stuff out and I would have literally nothing. She's very, very vulnerable. So he ends up letting her, quote, work it off, and repeatedly rapes her. So how do you deal with the weakness, which is there was a prostitution deal made up front? Now, we understand this as prosecutors, but you're dealing with a jury. So I found a quote online, and if you're wondering where I get some of these quotes, if I don't get them from the case, a lot of times I'm doing Google searches for concepts. And this is actually a French author that I found that wrote, the people who have no weaknesses are terrible. There is no way of taking advantage of them. The converse of this quote is true. People who have weaknesses are desirable. They can be taken advantage of. This is how the defendant lived. He used cons, not to steal money, but to rape. The evidence will show unmistakably he's a rapist. On November 19th, the victim was a person with a weakness. On that date, she was working as an escort, a prostitute. So again, it shifted the attention off the victim's behavior onto why the defendant chose her. So it's going to a weakness in your case. Manipulation, another general theme. It's good for when the defendant was well liked. If you have a clergy member, if you have a police officer, if you have a teacher that everybody liked, those are examples. Or a coach that, you know, kids just flock to. When the defendant was in a position of trust or respected by the community, again, a clergy member, a cop. Some examples of your theme of manipulation would be you can't judge a book by its cover, so that they understand there's something underneath this person's facade. Or a wolf in sheep's clothing. Interestingly, I tried a case a number of years ago where I had a school counselor that was well liked by the administration, and he claimed to, he compared himself to a wolf and said that that gave him special powers and special knowledge. And he would freak the kids out that he did have this special knowledge, and that's why they would not tell anybody that he had been molesting them. So I chose the theme of wolf in sheep's clothing. When we were going through the items seized from his office, we came across a stuffed animal, a little bit, about a foot high. And it was actually a sheep. It was a stuffed animal that was a sheep. And the case agent said, "Rachel, you need to look at this." And I looked over and didn't really give it much thought. And I said, "Oh, yeah, that's cute." And she said, "No, look at this." And that stuffed animal was made in such a way that you could peel the head covering off, and underneath it was a wolf. So this theme that I had chosen, wolf in sheep's clothing, he was actually, I think, subtly bragging about it by having that stuffed animal in his office at school. I think that was part of his narcissism. And then you can also have themes that involve a general theme where you have a targeted victim. Not every kid was molested. Not every kid was abused. And of course, you'll have defendant saying that, well, she had an eating disorder. That's why she was so thin. Not that I was targeting her, because look at all my other kids. All my other kids are fine. And it's also good for when the primary abuser is not the parent, not the mother. So it's like mom's boyfriend type situation. One of my friends in the homicide unit here tried a couple of cases, and we kind of sat around trying to think of a theme for her in a couple of her cases, and these were two that we came up with. The first one was a case where mom's boyfriend killed the child, and it had been a prolonged child abuse scenario. This child had been abused over months and months, and mom did nothing about it. Why was he targeting her? Because she was not his child. They had a child together, and mom was not protecting her, so mom was not acting as a mother would act. And so we chose the theme, no one's child. And that allowed Patty Stevens to just have that drumbeat. She was no one's child, to remind the jury of why this happened, because you're going to have a jury sitting there saying, how could somebody do this? How could somebody let this happen to their child? They don't see what we see on a daily basis. Patty tried another case where it was, again, mom's boyfriend, and he ended up drowning the 3-year-old in the pool because he felt like the 3-year-old was taking mom's attention away from him. And so we chose the theme, 3 was a crowd. And that gets us to the theory. Now, this is very important to remember. You can live without a theme. You can. I wouldn't suggest you do it, but you can live without a theme. But you'll die without a theory. A theory is a statement of the case, for example, your opening statement, that incorporates all of the facts into a cohesive account. All of them, good, bad, indifferent. A lot of people try their cases toward the legal theory, which are the elements of the offense, the who, what, when, where. But in a child abuse or sexual abuse case, you need to try it toward the factual theory, which is the why and the how. I realize that we do not have to prove motive, but if you don't show how something happened, you very well could lose. I like to compare it to this. This would be your legal theory. You can look at that, you can recognize it, you know what it is, but it has no depth, it has no hue, there's no richness, and it's really not anything that you'd be interested in, but this you would, because it has that dynamic quality to it. So when you're talking about your factual theory, you need to use the persuasive facts with the characters. For example, in the case that I read to you, to talk about how mom fit into all of this by reading from her journal that she's writing that she wanted to throw her daughter out with garbage. that you could almost hear the sneer in her voice as she wrote how the victim had less hair and had to wear a hairband to keep it down, what's sticking up. The setting is very important. So you can see the setting really at Dad's house was that the kids were isolated, that they were treated as second-class citizens. And so they didn't feel important. So when attention was paid to them, that was important to them. The time frame, of course, significant events, and what the defendant did by way of grooming, manipulation, and concealment. Well, what did that defendant do by way of manipulation? For example, he pretended to channel the voice of God. And we actually had an audio tape of him holding a prayer circle. It wasn't about blaming Dad for sexual abuse, but we got a taste of his changing of his voice. So that would be an example of the manipulation that was used. And then victim prep is critical. In the case that I read to you, we spent 10.5 hours prepping the victim for trial. And I think a lot of people might think that that's us telling her what we're going to ask and her answering the questions back. That is not what happened. We literally made a list of everything that was problematic about the case, and we asked her to explain, why did you do this? Why did you do this? And then that led to other things as well. And that's how that rich story came out. Now, that victim happened to be extremely smart, extremely articulate, but sometimes your witness or your victim cannot do that. They just don't have that capability. So that's when you get as many details as you can from that person, and then you consider using an expert. So for example, if that victim had said, I didn't want to go home, that's why I stayed in the hospital, but was really not able to articulate, well, I faked my psychological symptoms so I would stay in because my mom wasn't there hating me and my stepdad wasn't there molesting me. You can have an expert, a blind expert, talk about how kids will engage in behaviors to avoid the abusive situation. And then when you are going to call such an expert, make sure you talk about it during opening statement. Those experts, most states, put them on as cold or blind experts where they don't know the facts of the case and they're not there, obviously, to diagnose. That would be an improper use of the expert, but they're up there to explain victim dynamics. When I'm putting on such an expert, I will go through a list of questions about what do you know about this case? Have you read the police reports? Have you listened to the interviews? And I get a series of no's. So the jury, if they haven't heard about what this expert is all about in opening, is sitting there thinking, well, what good are they? So you need to lay the groundwork for that expert. And you need to reiterate during the testimony and the closing. Now let's talk about bad facts. I gave you a whole slide of bad facts involving the case I read. And again, the first few things, like draw the sting on problems. For example, if the witness has criminal history or the police mishandled the investigation, there is a reality that you're going to have to kind of warn the jury up front. But your bad facts regarding your victim, regarding credibility, regarding bad behavior, you can't just draw the sting on those. You have to incorporate those into your theory. So for example, in the opening that I read to you, you heard that she falsely accused her dad, but you also heard why. You heard that she falsely accused the boy at church, but you also heard why. You heard that she was a cutter and somebody thought she was trying to commit suicide and she was institutionalized 4 times, but you also heard why. So you have to incorporate those into your theory. One of my friends who used to be my counterpart at the San Diego District Attorney's Office, Kathy Stevenson, taught me something. When I was a new attorney, it didn't make a whole lot of sense to me, but it sure makes a whole lot of sense to me now. There are no good facts and there are no bad facts. There are just facts. And once I was able to incorporate that into my practice and how I presented cases to the jury, it made a world of difference. There are just facts. It's how it happens. Then we come to the closing arguments of the case. And I just want to give you a few tips to, bring it back to the jury, because a lot of times the victim has testified up front and there have been witnesses in between. For example, the police witnesses, the case agent, maybe the doctor who did the medical exam explaining why there were no findings. So you need to remind the jury of the victim. This is an emotional thing too. Especially if you have multiple victims where it might blend together, or if you have a long trial and there's been a long time since they've seen this victim. One of the things that I do is when they're after they're done testifying, or right before, I take a picture of that victim. And when I'm doing my closing argument, I will put their picture up there. Obviously, I have this person's picture blacked out. And I will go count by count. So if this victim was a victim of counts 1 through 4, it's going to look the same way every slide, but I'm just going to change the right-hand part where we talk about what made up that count. It's a good way to make them remember your victim. Timelines are important. We think that the jury is, writing all this down and they'll be able to figure it out, but oftentimes that's not the case. And so timelines that talk about when a victim disclosed in conjunction with when another victim disclosed but didn't know about the first victim. That's important to point out in a timeline. In a case where it hits the media, it's important to put a timeline up there in front of that jury to show that the interviews of the victims took place prior to any media coverage on this case. And that's something that your detective can testify to. Obviously, photographs and diagrams. And then back to that blind expert, you need to remind them of their testimony. Whoops, sorry about that. Someone was calling in. And so this is a slide that I might put up when I've used a blind expert. Children don't tell right away, especially boys. Special relationships, etc., lead to secrecy. A flight, fight, or freeze. Freezing is the most common. Children can love the abusers but hate the abuse. Children with problems won't be as resilient. They won't tell. They won't be believed. And families can be manipulated too. So it's very important to remind the jury of what that expert said. Now, some people choose to put that expert on after the victim. I actually, if possible, based on their schedule, choose to put that expert on first before the victim, because my opening statement will kind of set up the scenario, but that expert also paves the road for the issues that are going to come up during the victim's testimony. So in my situation, if this was the first witness, it may be weeks before I get up to give a closing argument, and they may have forgotten a lot of this. And then you need to address, of course, the defense. And sometimes you can do that visually. And let me give you an example. This looks silly, but this was a case I prosecuted involving a priest. And the 3 boys above and the 3 boys below were Arizona victims. And the 4 in the middle were other acts victims from Indiana. And I took their pictures after they testified, but obviously I've replaced them with these drawings. And what the allegation was that these kids had all jumped on the bandwagon. Actually, there were adults now. Had all jumped on the bandwagon so that they could sue the Catholic Church. They also said that they learned about each other through the media coverage. So I also used a timeline to show that the media coverage was after they had been making allegations to, if not the police themselves, at least to other people who could come in and say, yeah, he told me about this 3 years ago. And then I had to address, are these the type of people who actually would sue the Catholic Church? And so what we did was we took a quote that they made about how they felt about the priest prior to the abuse occurring. And we had them come in one at a time. I won't do that here. But just look at some of these quotes to remind the jury of how they felt. If you know anything about clergy abuse cases, you know that oftentimes these are very devout members of the church who would rather cut off an arm than hurt the church, but they're coming forward because they have nothing else, have no other way, or they feel they have no other way. It has nothing to do with the lawsuit in many of these cases. So one of the boys, as you can see 3 down on the left, he ran home to his mother. His dad had abandoned his family, and he said to his mom, "I just met my new best friend." Look at the one in the lower right. He was a security blanket, the only one I had. So this also reinforced the dynamic of these kids did not have intact families. So that was part of how this priest moved into the family. So it reinforced that, and it also showed really how much they cared for him. And then what we did was we took the same exact slide and we put up quotes also that came out during trial about how they felt once the abuse occurred, how they felt about having to testify. Look at the one, I did put priest's first name, 3 down on the left. That was the same person who said, "I just met my new best friend." He literally, during the trial, looked at the priest and said, "Because of my faith, I'm alive." And then he turned his head to the priest and said, "Paul, you scarred me." It was like a pin drop in the courtroom moment. Upper right-hand corner, that victim said the next day after the abuse, "I was like a zombie." And then I think the most poignant one was the lower right-hand corner. That was the one that talked about he was the only security blanket I had. When he was on the stand, we said, "How did you feel the next day?" He literally turned his chair 180 degrees away from the courtroom and sat there sobbing, and all he could get out was, "I just can't believe, ... He didn't finish that. So it reinforced the notion of how injured these kids were, these guys were, how much they don't really want to be here. And so it addresses the defense. In your rebuttal argument, never abandon your theme or theory. So Stanley Reimer's God was talked about in opening, it was talked about in the first close, and it was talked about in rebuttal, because it's what explained the overarching explanation of how the victim was manipulated into doing what happened. And put the conflicts in perspective. If the defense is saying, like in this priest case, well, one victim from Indiana knew one victim from Arizona, put that in perspective as to when they met and what they talked about and what information had already been shared with other people so that they weren't getting together to get their story straight. And then it's important also, if you have a defense attorney that's trying to sneak in a defense that doesn't apply, such as consent, remind the jury that the defense doesn't apply. So for example, in rape cases, I have this slide, acquiescence doesn't equal consent. In the case I told you about where the man was pretending to be a cop and the victim was a prostitute, acquiescence did not equal consent. I think it's also important to make policy arguments. This is a police officer that I prosecuted, and he had 3 victims. One of the victims was a meth addict who had a fugitive of justice warrant for her arrest. And when she was originally contacted, she was trying to burglarize vehicles, and she lied about her name because she knew she had the warrant out. That was one victim. The second victim was driving erratically. He never completed an investigation, so we don't know exactly why. And the third victim was out smoking marijuana with a guy she just met. She was 17, he was 27. They met on a phone chat line in a park after curfew had passed. So you can understand why a very squared away looking police officer sitting on one side of the courtroom and those 3 victims sitting on the other side of the courtroom might create a problem for some jurors. So we needed to remind them, as a matter of policy, why should you care about this case? And so we literally had this this slide in the next. The defendant, a sworn officer, omitted important details to cover up his crimes. What he had done was talked about having a drug tech come out and test the marijuana at the park, and actually it didn't even happen there. It happened after he had sexually abused the girl and dropped her to grandmother's. So his police reports omitted some of those details. The defendant, a sworn officer, lied to cover up his crimes. The defendant ignored others' criminal activity to try to cover up his crimes. Like I said, he did not investigate the erratic driver. And then the 27-year-old that was out smoking marijuana with the 17-year-old admitted he'd been smoking marijuana. The officer had run him, and he was driving on a suspended license. In Arizona, that's a felony, driving on a suspended license under the influence, and yet he told the guy to take off and let him drive away, endangering other motorists and ignoring a felony to keep a 17-year-old in the park. And then finally, we had this slide. Why should you care? Because he sexually violated 3 women. And it's just bringing it back, the attention off of the victim's behavior that the jury may not approve of, and putting it back on the defendant where it belongs. So that is the end of my slides. I wanted to save a little bit of time at the end to answer any questions that you have that you want to send to Dee.
Hi, Rachel. So we have 3 questions so far.
Okay.
And our first question is, our judges do not allow note-taking during opening or closing. What do you recommend?
Okay.
And then, do you want me to go on and read the second and third questions?
Let me answer the first one first.
Okay.
In that type of situation, I would probably do as much as I could to burn it into their memory, and that's when I think visual depictions are even more important, so that at least maybe they can remember what the slides look like, because they sure won't remember what you're saying in terms of family structure and that type of thing. The other thing that I think you could ask to do is, okay, we're not going to have them take notes, but can I give them a chart of the family tree, at least? In the case that I read to you, also to make a visual impact, I didn't show it to you all today, but we showed pictures of the victims' scars from cutting, and actually some of them were very recent and still healing. So to make that visual impact, but certainly another thing you can do when they're not letting you take notes is you can at least put the counts up there and draw their attention to what they need to listen to, whether it be, you know, that the victim was under 15 or that it was penetration versus touching. So at least they can tune their ear to what they need to listen to. Okay? Dee?
Now, our next question is, how do you address delayed disclosure during voir dire?
How do I just address delayed disclosure during voir dire? Well, ideally, you can ask for a jury questionnaire. A lot of judges won't do that. In Maricopa County, we have everything under the sun in terms of what the judges will let us do. Some don't let us do anything at all. Some let us do a jury questionnaire. Jury questionnaire is my favorite. If you are allowed to submit questions or at least get up and ask some questions, what I'm going to ask is something along the lines of, they've probably been read the indictment at that point, so that they may have heard that this took place over a number of years. I'm going to say, you've heard the charges in this case. You know that this took place over a number of years, which means the victim didn't tell anybody for a long time. Is there anybody who, based on that fact alone, would question the credibility of the victim? That would be like a yes or no type question, and then I would follow up with something. Or you could ask if the judge will let you an open-ended question, can anybody imagine a reason why a victim wouldn't tell right away? You're less likely to get that asked. Now, one of the things I would tell you is this: if you get somebody answering and they say something that's negative, like, Yes, I would question a victim's credibility if she didn't tell right away. What you then do to follow up is you ask the opposite of what you want. So you didn't want that. That's not good for your case. So you don't say, does anybody disagree? Because that's indoctrinating the jury, and it's also painting the target for the defense attorney on who to strike. What you say is, does anyone else agree with that? Because that's who you want to identify. Likewise, if the person says, no, I would not question someone who delayed, kids do that because they're afraid or embarrassed, then what you want to ask is the opposite of what you want. Does anyone disagree with that? And hopefully that will get some discussion going so you can pick out the people you don't want for delayed disclosure. Dee?
Yes, our last question is, do you have a sample of voir dire questions?
Actually, I have a jury questionnaire that I can send to you all at APA, and I'd be happy to do that, and then you can send that out.
All right, thank you very much.
You're welcome. In fact, what I will do is on the case that I read, I think I have the jury questionnaire still on that, so I will edit it for victims' names, and then I will send it to you, Dee.
All right. Thank you, Rachel, for an excellent and informative presentation. All APA webinar materials and recordings are available on our website. Please join us on Wednesday, March 15th for our webinar, Developing a Kids in Court Program, presented by Erin Price, an Assistant District Attorney from Dallas. If you have any questions or concerns, please email us at webinars@apainc.org. Thank you for attending. Have a great day.